Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We are using Zoom with a goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder, this is a video conference. Per Bagley King requirements, all cameras must be kept on during the duration of the meeting. If you are unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of the surroundings behind you. All committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen and then select enable transcript, auto transcript, excuse me. Thank you.
Thank you. So let's call the meeting to order. And Kim or Erica, one of you are doing roll call, I believe. I think we now have a quorum, so that's great.
Yes, I'll take roll. Blakemore?
Yes.
Alsaroff? Connolly?
Present.
Wong?
Here.
Mahoney? Sandville? Vargas?
Here.
We have a quorum. And then I will go through our liaisons and State Bar staff. Selena Copeland?
Present.
From WAC. Melanie Snyder from the Judicial Council.
Present.
Yoon Kim from the Judicial Council. And then I see Juan is here. I'm here. And we have our presenters, Kim and Mara online as well. Thank you.
Terrific. So should we, let's do, if there's any public comment, let's take those at the beginning.
No one has their, oh, sorry. Well, 1 second.
Sure. Looks like Erin Smith is here and has a comment.
Hi, am I unmuted? Yes, looks like I'm unmuted. Hi, everyone. I'm a member of the Legal Services Trust Fund Commission, so I'm here with my public hat on, I guess, just to listen in, because I know you're going to be talking about support center rules today. And as I think you all know, I was an executive director of a support center for 11 years, so I'm pretty familiar with those rules, and I'm just kind of interested to hear what the committee is considering. And also just want to, offer myself as a resource if it would be helpful to hear, anything about my experience running a support center, or my comment at any point. I'm happy to provide that for you. So just here to listen and provide assistance.
Thanks so much, Erin. Appreciate you joining. Okay. I think that, if I'm not mistaken, takes us to our minutes from our last meeting, right? Okay. Has everyone had an opportunity to review the minutes? Welcome, Kim. Are there any questions, changes to the minutes? Not seeing any. Is there a motion to approve the minutes?
I'll make the motion.
Thank you, Erica.
I'll second that.
Thank you so much, Tony. Okay, let's do a roll call.
Alsaroff? Connolly?
Yes.
Wong?
Yes.
Mahoney? Sandville? Vargas?
Yes.
Blakemore?
Yes.
4 yeses, no nos, the motion passes.
Okay, and are there any staff updates that we want to do?
No staff updates.
Okay. I'll just say welcome to everyone. Thank you for taking time from what I know is everyone's busy schedule. I think we have a pretty interesting agenda today, 2 big topics to dive into. So look forward to the discussion, and let's take up the first one, which I think is the staff memo on the proposed state bar rule addition. I'm kind of in the process of where we are in that, and I think Mara is going to present that for us. Am I right?
I am, yeah. And Erica actually
Excellent.
has a brief introduction to provide before I
Okay.
begin.
However you all want to do it, that'd be great. Thank you.
Great, thanks.
Yeah, thank you. So I know at the last Rules Committee meeting, we went over the work plan for the year, and one of the topics that we had mentioned was monitoring visits. And as staff got kind of further into looking into the need for potential rule changes related to monitoring, we essentially concluded that a lot of the work that has been done on these or may need to be done is related to kind of our practices and procedures internally as an office, but we did identify sort of a small change that was presented in the memo that we felt was related to a prior topic that the Rules Committee had addressed, which was the quality controls and noncompliance topic. And so we wanted to bring that to you all for consideration. And Mara's going to go in more depth about sort of what specifically this potential rule change is hoping to achieve. But we felt that as far as monitoring goes, that this would kind of be the most helpful kind of modification to the rule to put everybody on the same page in terms of expectations and clarity. So it's really viewed as sort of an outgrowth of or an add-on to the prior topic that was addressed back in November rather than a separate topic on its own.
Sounds great.
Okay, can everybody hear and see me now?
We
And
can
can you-
hear you,
Yeah.
but we can't see your screen, which it looked like you were pulling up
Okay.
at some point.
Yeah, I pulled it up and then I got dropped. So let's try that again. All right, how about now?
Nope.
It says, oh, there it is. There's just a delay.
Okay, great. So this is the recommendation to amend State Bar Rule 3618, 3681E. And the committee, as Erica mentioned, had previously approved amendments to Rule 3661 and 3681 for both quality control purposes and also in terms of non-compliance. Those pending amendments would move what is currently Rule E to Rule U, but because those amendments haven't been officially adopted by the commission, it is still considered to be Rule E. The rule as it stands now lacks a certain amount of clarity in terms of post-monitoring responsibilities and then the implementation of recommendations. So in order to provide that clarity and strengthen the oversight mechanisms, which is part of a larger effort of the Commission's strategic plan, staff decided to recommend these changes to Rule E. So the current rule states cooperate regarding any reasonable site visit. And the proposed amendment would read instead, cooperating regarding any scheduled monitoring visit, address resulting recommendations related to quality control standards, and implement corrective action plans developed to meet compliance requirements. The changes, reasonable site visit to scheduled monitoring visit, reflects the current terminology used by the state bar and that our grantees are familiar with. So the rule would now reflect current terminology. It also adds the requirement to address resulting recommendations related to quality controls and standards, and adds a requirement regarding corrective action plans to meet requirements standards. This would codify current state bar practices and grantee expectations. So the recommendation or the recommended amendment is not a change in practice. It is simply a change in the rule to reflect practices that are already in place and which grantees currently experience. It does strengthen compliance standards and maintains the reasonable expectations that we hold. This change would also just establish a very clear framework for post-monitoring visit responsibilities. And as I mentioned before, this is in line with strategic plan goals by increasing accountability and transparency, improving community service efficiency and effectiveness, and enhancing the commission's impact through strengthened oversight. So this is the resolution as it's currently written, but before we move to that, I wanted to ask if there were any follow-up questions or any clarification I can offer.
I'm not seeing any at the moment. I think there might be some as we sort of go through the material, but I think we all understand the process that you're using to make the change.
Okay.
Okay.
So the resolution as currently written is resolved that the Legal Services Trust Fund Commission Rules Committee recommends approval of the amendments to State Bar Rule 3681 as outlined in Attachment A, and recommends that the Legal Services Trust Fund Commission that it release the proposed rule together with the pending rule amendments from November 6th, 2024 for a public comment period of 45 days.
Okay, were you going to provide any of the background about the specific? I mean, I have two questions at least.
Absolutely, yeah.
Before we approve it. So I absolutely support a clear understanding about, the compliance issues. And I would acknowledge, I think there's been occasionally some confusion about this. So this does an additional thing, which requires that grantees, I think, implement. It's really a question, I guess, the recommendations that come out of that. And recommendations aren't really the same as compliance issues, because compliance is what grantees are, for the most part, already obligated to do. So I'm trying to understand the sort of to my thinking, those two things have been conflated into a single standard. Like now you must comply with the recommendations and you must comply with the compliance issues. And I guess as we're going through this, the reason I'm in part asking that is in the memo that was posted, when you talked about compliance for quality assurance, and you referenced as an example of that the ABA standards for civil legal service. And I went back and looked at those because my recollection was that those standards are aspirational, meaning they're what legal aid programs should strive for. Not something that they currently have to comply with, and an acknowledgement that not all of those standards, quality assurance or otherwise, are things that grantees have to do depending on the work they do, the size of the organization. There's a whole variety of different considerations. So I guess I'm just trying to understand sort of the framework from those two questions.
And Erica, I don't know if you had additional context to provide with,
Sure. Yeah. So what you just mentioned, Catherine, is something that we were mindful of and that we were trying to address through the rule. But if you and the rest of the committee don't feel that we're getting at that, we should definitely look at the language more closely. But you are correct that the recommendations piece is in reference to the ABA standards. That's kind of our guiding document when we go on monitoring visits. And we agree that grantees are not to be held to a specific requirement within those standards. What we do when we conduct our monitoring visits, and I don't know if any members of the committee have seen sort of our recent monitoring reports that go out, is we break it down into recommendations and requirements. So recommendations are those that are related to the ABA standards, where we offer our insights, our recommendations, suggestions for ways that grantees might want to start thinking about addressing certain topics or incorporating it into their work. But we don't have a specific outcome in terms of you must do X in order to be found in compliance. But we do have an expectation that grantees engage with us on those topics when we bring it to their attention and provide some feedback about, if that is on their radar, things they might be doing in that regard, things they would be thinking about doing based on the feedback they received. But there is no one, we're not trying to be prescriptive when we make recommendations, because we do understand that it may be highly variable depending on all the factors that you just mentioned and others related to the organization that we're working with. The difference is that what we have as requirements is those would be things that are related to the statute, the state bar rules, things that must be completed or in accordance with our governing authorities in order to be found in compliance. So those would be what we're working with the grantee to come up with a very specific response or solution in order to make sure that they are in accordance with the governing authorities. So we were trying to get at that by saying that we still want grantees to engage with us by addressing resulting recommendations, but not that they need to do something very specific, whereas implementing a corrective action plan envisions having working with the grantee to go through those steps to make sure that they don't have to go through any of the other procedures that have been outlined in that prior quality controls and non-compliance topic that you talked about back in November.
So what happens if a grantee and the bar disagree with a recommendation? Like the bar says, we want you to do X, and the grantee thinks because it came from the ABA non-binding things, they don't actually have to do that. And it seems like they would still, under this rule, have to do something. So from my perspective, it's almost more like if a grantee and the bar agree about the recommendation, that's fine and it should be implemented. But I feel like this could be read to say, like, we're the bar, we did a monitoring visit and you must address this recommendation, kind of whether you think it applies to you or not. So trying to, I guess, find a path for a little more flexibility with the recommendation side. I'm absolutely fine with the implement corrective action. I think that's compliance, and there's not really a choice about implementing compliance in my view. So I'll leave it at that. And Erica has her hand up. The other Erica.
Well, I just want to flag, there's like two different words being used here, right? So implement, as I think we've all agreed, means that there is a requirement to actually do something, but the term address, and maybe there needs to be just a little bit of wordsmithing, but address seems to me to get at what Erica's saying, which is some engagement. And maybe we need to just say, maybe we need to add something that says engage with staff to address. But I take staff's point that like we would like, I think there's some value in having grantees at least be in discussion with us and provide like a reason, like explanation for why they don't want to adopt a particular recommendation. And I understand that we don't want this to be read to say you must comply with this. I mean, that's where I think implement versus address, that difference in wording is kind of important. But I do think it's important for us to have something in the rule that says, we want you to take our recommendations seriously and explain to us in particular why it may not be a good fit for your particular organization. I don't know, maybe that's too prescriptive, but I do think there's some value in having an obligation to like have that engagement.
Yeah, so I think you and I are saying similar things. I think, Erica,
Sure.
I don't have, there's no problem having a discussion about a recommendation, how I, as a grantee, want to implement it, and then a commitment to implement it, right? But I feel like it has to be that engagement discussion and reach agreement about like what you're going to be doing, which is just a tweaking of like a dress, I guess.
Can we tweak to say something like, must engage with staff to address resulting recommendations? Would that be so that the obligation is the engagement with staff?
Yeah, I was
Or
sort
is
of
that,
like, yeah, I don't know. I was thinking like you would have a conversation and you would reach agreement about what you're gonna address out of a recommendation, because the recommendations can actually be quite helpful. I mean, I've had all kinds of monitoring visits from all kinds of places in my life, and hearing what people think about gives you food for thought for the future, where you might want to go, but I might not be in a position to do it now, right? So, to me, that interaction about what you're going to do and some agreement about what you're going to do is important. But Selena may have opinions too from talking to grantees about monitoring visits.
I mean, I think my main input, and those of you who've worked at legal aid organizations, like including Erin, might have other thoughts too. I think it's helpful for organizations to know what is a requirement, a state bar requirement, and then what is a best practice. And the kind of corrective action plan feels like it's more about the requirements, but the best practices could be, what is your plan to begin to implement this? And just one specific example I can think of is around cybersecurity and security of client files. Like there are some legal and ethical requirements around that, but there also may be some best practices that organizations may need technical assistance to figure out how to do it. And my worry is that if there's too much of a stick approach, then people will be afraid to ask questions. And I do think that your technical assistance is a lot more of a carrot, where you're saying, oh, if you need to figure out how to do this, here's a training on that. Because I want all the organizations, if they're trying to figure out what a best practice is, that they and especially if it has an impact on their eligibility for the IELTS award or for their calculating their QEs for future IELTS awards, that they talk with their state bar staff and they're not afraid to.
so I guess the question I have though then is there like an effort to, or is the suggestion, Catherine and Selena, to take out the address resulting recommendations or to change the language? I'm sort of proposing like this, like you engage, or I don't want to obligate an agreement because there may be situations where there won't be an agreement. So we don't want to say you must reach an agreement, because that's essentially then we're just getting into requirements. But I do like the idea of having some obligation to engage. We're all sort of in agreement about, is there a way that we can wordsmith this, or is it that your position is we should just take that out entirely? That's just,
I wasn't saying
yeah.
take it out. I haven't said take it.
Okay.
I think it needs some tweaking. I think in the end, like it, I don't know. Let's hear what Tony has to say. Looks like she might have a solution.
I have something, but I don't know if it's the solution. It's some added information. I think maybe to address kind of both sides, it might be, would it be possible to say develop and implement? And I don't know if the staff wants to review these plans, but develop and implement an approved state bar plan that addresses or developed to meet compliance requirements. That allows them to kind of take the onus upon themselves to develop a plan to kind of meet any gaps that we've identified, but also give staff the ability to say, no, your plan doesn't meet the requirements, or it doesn't address the gaps appropriately. And that kind of is a conversation that staff would have with these entities.
So Tony, just so I'm clear, are you talking about the second phrase, implement corrective action, and putting words there, or are you talking about the recommendation section, or?
I'm talking about both of them together. So what you would do is to develop and implement a corrective action plan right?
But this isn't a corrective action plan. The corrective action plan is only about the compliance part. And the other part is these aspirational, in part, quality assurance standards that there isn't really a requirement that you implement them at least exactly as written. That's the ABA standards that are,
Okay.
I mean, they're very long. They're, I don't know, like they feel like they're 100 pages, but they might not be that long. They might be 50 pages.
I guess if the
Yeah.
recommendations, then I don't understand why it's kind of confusing when you put it in a rule where it's best practice. It shouldn't be it. When you put it in a rule, it makes it seem like you need to do it.
So I think you said more, I mean, you've said what I'm trying to find a solution for. So, I mean, maybe in part, like by having this in the same sentence, it adds to that confusion. And I wonder if we broke this into two things, right? Like that, does that make it any better? Because I think we all agree that cooperate regarding any scheduled monitoring visit and implement corrective action plans developed to meet compliance requirements is absolutely appropriate. And then we could say something about, in addition, work with state bar staff to develop a plan to implement recommendations, or something that would be something that's not like you have to do it and you have to do it to meet this particular standard. I mean, it needs to be this interaction, I think, as Selena described it, with get technical assistance from the state bar staff to implement the recommendations, something something that doesn't make it's something that distinguishes it from a corrective action plan.
I think
Right.
hearing, sorry, Erica.
No, go ahead, Mara. Yeah.
I think hearing all of these comments, I agree. I agree with all the feedback that's been shared. I do think it is helpful in order to continue to foster improvement towards certain standards, to acknowledge the recommendations as a part of the outcome is monitoring visits. But I do also agree that including them in the same sentence does give the appearance of a requirement, as opposed to, as you've all put it, like an aspiration. So maybe if I could recommend essentially like taking all the feedback, and implementing it all and changing it to something along the lines of cooperate regarding any scheduled monitoring visit, engage with staff regarding resulting recommendations. And then as a new sentence, in addition, work with state bar staff to implement corrective action plan. And that way we've changed the word address to more explicitly say, like, we would like you to engage in a conversation about things that are aspirational, but then in a separate sentence that is a little stronger, make it clear that we want them to work with state bar staff on the implementation of things that truly are requirements. And that way we can hold ourselves to a standard of continuing to support improvement, but also, like, when appropriate, like really enforcing implementation when there are non-compliance issues. How does that sit with everybody? I can type it up if that's better. I know I just kind of rattled it off.
Yeah, I mean, I think there's two components to the very clear rule. The first is cooperate regarding any scheduled monitoring visit and implement corrective action. Those are the two, like, clear verbs, like you have to cooperate and you have to implement. And then, so I would link those two together, and then I would say, in addition, and then what you were saying seems.
And then engage with staff resulting recommendations.
Engage with staff
Okay.
about recommendations seems appropriate to me. And I think that's the verb that Erica was using. And so we should check in with her about whether that dividing it up that way makes sense or works.
Hmm.
And
You mean me or Erica Carroll?
I meant you, Erica Connolly, sorry. If you both, it wasn't just like Erica, we could say Erica C, but.
I know it's complicated. Maybe what we could do is actually do you for the two that you're talking about, cooperate and implement. V becomes engage with staff regarding recommendations, and then TUVW becomes submit financial reports. Or we can put engage goes down to W, but basically break it up
It's
into like a
fine.
separate
Yeah, the order-
UVW, whatever. Yeah.
Yeah,
Oh, sorry. That's me.
that seems fine.
I'll shut up.
No, I think it's good. I think we've sort of settled on that. Tony might have a comment or a question too.
I have a question, and this is just because I'm unclear. And maybe this team can shed a little bit of light on this for me, because when I read it and it says resulting recommendations and then corrective action plans, does the corrective action plan not include recommendations? And I know that we use the word quality control and then the compliance requirement as two different things, and we understand that, but I'm just wondering if somebody outside of us has that same understanding, or do you have to be in the business to understand? Like if somebody were new and they came in and read this, would they need some information to understand that those mean two different things? Because I assumed by reading it, I thought it was one and the same.
So I think a program that's undergoing a monitoring visit and is receiving a report like this, or even just engaging in the monitoring visit process, like we do run through the terminology and the expectations, both at the beginning of the monitoring visit and then at the end when they get the report. And there is a distinction that we make between recommendations as opposed to a corrective action plan. So I think that's where if somebody were new and hadn't gone through that process before, there would be I won't say a training period, but there would be an introduction into the difference between those things and the expectations in terms of outcomes of a monitoring visit.
And I think by separating them into two different things, and Erica, because she was on rules last year, I wasn't, seems to understand there's this framework with the new numbering that will, I think, make it even clearer than it is in kind of this slide. Like you have to cooperate, and then you have to implement corrective action. And there might be something else related to fiscal, but then you also have to engage in staff about quality control standards. Recommendations relate to quality control. For me, at least, that makes it clearer that they are different things, and that the expectation about what you would do would be different for the two things we've been talking about.
Yeah.
So I agree with you that it's just, I think we created unnecessary confusion by having it in one sentence. Does that give you what you need, Mara and Erica, or
I believe so. I've typed up what would be the new recommended rules. And Erica, how would you like me to, because the resolution as written would also need to change in order for us to take a vote. So how would you like me to do this?
I think that the resolution could say something along the lines of like as revised during the meeting.
Okay.
And if we could enlarge the breakdown, the UVW subsections that you were presenting, just so
Can
everybody.
I read that back to everybody, or do you need
I
me to
just
share
think
it on
we
my
can't
screen?
actually.
It's just a little difficult to see.
Yep.
Much better.
Much
Thank
better.
you.
Okay, there we go. No problem.
And then I think I would just say engage with staff regarding recommendations. I don't think resulting needs to be there personally. So I'm kind of this plain language, less is more person.
I appreciate that.
Do people have questions about this framework?
If I may.
Yeah.
I was just wondering if V and W should be more like a 1 and 2 under U, because the rule is very long and these are
You know
specific
what,
to the monitoring.
Erica, I'm actually not like wedded to like U, V, and W or 1 and 2, and I don't know that do we actually need to pass it in in that format, or can we just leave that to you?
I think we can leave it to us, Erica, because Brady and our other
Yeah,
OG staff doing the rule stuff,
Sure.
we're gonna come back and smooth that
Yeah,
out.
so I think if we just say we're passing
is the language, yeah.
resolution and this is the language, I feel like regardless of alphabet or numbers or however else it might be, it's gonna be fine.
Sounds great.
Selena,
I wanted to offer LAC and the broader community as a resource for the best practices and engaging with state bar staff. A lot of the conversations I've had with executive directors over the very recent history is just an eagerness to do things better, but wanting resources to do that. And so I think that part of engaging with state bar staff around best practices is if you know organizations that do certain things particularly well, I do think that organizations would be eager to help each other out here, whether it's like, for example, functional timesheets or allocating shared expenses or anything that smaller organizations may not have the infrastructure and mid-sized organizations do. So it doesn't need to make it in the rule. It's just, I think that part of that engaging is using your bigger community.
thanks for that, Selena. Go
If we're
ahead.
ready for a motion, I'm happy to make a motion.
That'd be great, Erica, please. I consider that a
I move to
motion.
adopt yes, to adopt the resolution as amended, with the rule as amended at the meeting today.
Is there a second to that?
I'll second.
Thank you, Javier. Any other questions, discussion, comments? Okay, could Erica or Kim call the roll for that?
Sure. Elseroff, Connolly,
Yes.
Wong,
Yes.
Mahoney, Sandville, Vargas.
Yes.
Blakemore.
Yes.
4 yeses, no nos, the motion passes.
Thanks so much for the good discussion and to staff for their willingness to think about a way to make it as clear as possible. And I definitely think this will move the needle in terms of people understanding what their obligations are. So really grateful to everyone for the good thoughts and the good questions. Actually, a lot of times from questions where it's just like it's not clear, like that's also helpful, I think.
Yeah, appreciate the feedback and support. Thank you all.
I'm so
Okay.
excited. We have a rule going out for public comment. Yay. Sorry, I'm like really excited about that.
It's good. And it was good to like step back. I thought I really appreciated staff stepping back and saying, is there something missing from what we're putting out and the opportunity to fix it? So I guess it goes to the commission at our next meeting in May, and then it goes to the State Bar Board of Governors and then gets sent out for comment. And then I gather it comes back to us in case there are comments.
We get to send it out for comments.
Oh, you got to send it out.
Yeah.
The
Okay,
commission.
great.
Then it goes to the board after.
And then it goes to the board.
Yeah.
Okay. And if there were comments, it would come back to us then.
Yeah.
Okay.
Yeah.
That sounds great. Thanks for clarifying that. Selena.
With my regular request for technical assistance. I have also been hearing a lot about, I would say, I wouldn't say compliance, but just like issues that your grantees are seeing with the CTAP compliance, like I said, it's compliance, and other things with the My State Bar portal. A lot of organizations is based on their size are having some confusion around what is required. So I would love it if the bar would be willing to, before we all have our dues, just doing a reminder about what boxes to click. Because I'm afraid that some organizations are non-compliant just because of all the additional online requirements now. I don't want an organization to be out of compliance if, 30 of their lawyers don't click the right box.
Yeah, I mean that's something we can rate because the CTAP stuff doesn't live in our office, but those are our colleagues. So let us try to and we've regularly interfaced with them because they help with our IOLTA kind of they collect our IOLTA revenue for us. So let's see what we can do and coordinate those efforts. Because I know there's a lot of confusion this year around that.
Yeah, and I think the state bar is now fining or IOLTA funded organizations for attorneys who have not done the CTAP compliance checkboxes right. So your grantees are paying fines to the state bar. And I think it's none of them are out of actual CTAP compliance. I think it's just like they don't know the box to click. It's confusing to many of us. We've all kind of shared screens with each other to know what to click.
Okay, I think that takes us to our next topic, and a small working group, which has been Tony, Amin, and me, has had the pleasure of working with Kim and Erica on the support center codification topics. And I think Kim is going to take the lead and Erica may have some introduction first, but take it away and thank you. And this is intended to be interactive because we actually want to get input from people that are not on the working group. So there's going to be a intro of here's where we are, here's the topics we're taking up, but we actually want help from Javier and Erica to give us your thinking about what do you think should be in or out of some of these discussions? So that's kind of how we're approaching things.
Thank you so much, Catherine. And I'm going to just share my screen to get our slideshow going here. Thank you, everyone. Hello, Erica, Carol, and I are pleased to be presenting on this topic today with our incredible working group members, Catherine, Tony, and Amin. I am Kim Turner with, hopefully, can everyone see my screen properly right now?
Mm-hmm.
Okay,
yes.
Great. I am Kim Turner, Senior Program Analyst with the Office of Access and Inclusion. And we are, as Catherine mentioned, excited to have an interactive conversation today about support center requirements and just much appreciation to our working group members who've already provided great input. So we're going to share with you a little bit about what we have done already and where we're headed today. Let me just get to my agenda. So we'll give a little bit of background, talk about the topics on deck for today and the timeline ahead. We're going to then focus in on some of the phase 1 topics, which we'll delineate for you in the next slides, go through some of the relevant authorities and guidelines that are already in place, have a discussion about the phase 1 topics around support center requirements, and then be ready for next steps. And of course, thanks to everyone for their engagement. So I just would also quickly add, this is a very exciting topic, an important topic. And I'd also add that I have been an attorney in legal aid for 2 of our grantees in my past. And as a QLSP attorney, I've worked with support centers and appreciated support center work a whole lot. So I know a lot of us come in with legal aid background, but I just vividly know how much the relationships between support centers and QLSPs is helpful to our community. So much appreciation. So in terms of background, and I'll do some table setting, and of course, I look forward to Erica, Carol chiming in and our working group members, but just some background that folks know that we have been tackling a number of topics around codification in the recent months and years. And so in 2019, many know that staff and the Legal Services Trust Fund Commission agreed to engage in this process to revise and or codify grant-making decision points around IOLTA, EAF, other grants that we give. And the idea is to increase transparency and consistency in administering those funds. And so we are lucky to have already launched a lot of work around the topic with our working group members. And we've had a couple meetings in April. We're going to continue meeting, and we're looking at topics throughout this year. And some might wonder, we just had a great discussion on a rule amendment just now, previous to this agenda item. Why are we taking a little more time with this topic of support center requirements? Well, the reason is that it's very important and it's multifaceted. So we'll get into the different topics that we're going to talk about, but we want to make sure that there's a lot of room for input from our legal aid community and from our commissioners and from stakeholders, you know, grantees, of course, staff. And so we wanted to give everything its due time. So we are going to be culminating this process in a longer memo in the fall that will be presented to both the Rules Committee and then subsequently the LSTFC for approval. So that's some table setting around process. We did want to remind folks, and I know many know this well, but not everyone may remember that we are working with about 115 state bar grantees right now, and 93 of those are QLSPs, Qualified Legal Services Programs, and 22 are support centers. And in the slide there, you can see how much they've been granted under the IOLTA and EAF grants, about $1.7 million in IOLTA funds and over $217,000 in EAF funds. And then in case there's questions, you know, I know some folks do know the different support centers that are out there spanning the state, the critical work that they do. I'll just, you know, randomly name a couple in case it helps, you know, remind folks of who are our support centers. You know, National Housing Law Project, Work Safe, you know, Child Care Law Center, Justice and Aging. I'm naming several, Western Center on Law and Poverty, et cetera. So just mentioning a couple of names so that folks can put in the front of their minds the type of work support centers are doing for our next set of discussion points. So we did, you know, obviously want to remind everyone transparency and consistency is at the forefront of this process. We want to make sure everyone understands the requirements and that they're consistently applied. And then we also want to remind folks that the IOLTA statute that animates the support center requirements and the rules were developed a long time ago. And the rules, well, and the statute are emanating from 1980 and forward. Obviously, the rules have evolved over time, but we just want to make sure that the support center requirements are reflecting today's civil legal services landscape. Things have changed since IOLTA went into effect and since the rules began and have been amended. So we're in some ways updating requirements as well. And then before I get into the timeline, Erica, is there anything more you want to add on that bigger picture? And then we can jump into the timeline.
Yeah, no, I think that was a great, great overview. And as you all know, a lot of our rules work, especially at the very beginning, was very QLSP focused, QLSP heavy. And so we're excited to be able to turn to the support centers and give them their due and, you know, work on these updates for the benefit of everybody involved, the commission, staff, and our grantees. We think that the end result will hopefully be a great benefit to all of us. So thanks.
Thanks, Erica. Thank you. I appreciate that. And, you know, also just to flag that I think we're all kind of kaleidoscopic in our perspective. So, you know, folks have been grantees or are grantees, folks have been stakeholders that are advocacy organizations in the space. Staff, you know, have the role of applying these guidelines day to day when we're looking at eligibility questions and explaining things to grantees or prospective grantees. So we really want the rule amendments and the subsequent rules to be digestible and, you know, really easy to understand. I think to Selena's earlier point about lots of boxes to check, we want to make sure folks know which boxes to check around these topics and make it just very easy and logical. So our phase one topics that we've started tackling and we're reporting on today, and this is a report out. This is not going to be a proposal of a specific rule amendment like you just saw. This is actually more preliminary where we're getting input on these phase one topics today. And then we're going to work on, you know, wordsmithing final rule amendments and then move to the phase two topics that you see on the slide there. Work on those rule amendments, you know, word by word, and then combine it all together in an omnibus memo for the fall that, of course, would have legal aid community feedback, you know, added as well. So today we're looking at legal training, legal technical assistance, or advocacy support, and that's, you know, the work done by support centers in those areas. We're talking about what activities fall into those buckets. We're going to talk about office space, so what constitutes office space, and we're also going to talk about the national work that support centers do, or at least work outside of California that benefits California, and discussing like what does that mean. And you can see later on, we'll be doing the phase two topics around significant level. So what is the significant level of this work? and what constitutes a statewide approach of a support center. How do we make sure that the work of the support centers is in fact statewide? And there are other topics that have emerged. There are other rules that do raise support center work and requirements. So we may be filtering in some other parts of the rules over time. So, that's a high level view of the timeline. And then we do want to flag that deeming is, of course, a part of this conversation. As I mentioned, there are many components to support center work. So we are projecting working on the deeming topic next year in 2026.
And if I could just jump in really quickly, Kim, for newer members who might not be familiar with the deeming process, it says in the statute that support centers that were in existence that came into existence after December 31st, 1980, to qualify for these grants, they need to be deemed of special need by a majority of the qualified legal services projects. So the way that is currently implemented is that we have a sort of a triannual voting process where QLSPs have the ability to vote for the relevant support centers that year, whether they deem them a special need, and we need a majority of the QLSPs receiving grants at that time to say yes. So just a very brief overview, and we can get into it more when we reach that topic. But yeah.
Thanks, Erica. That's really helpful. Yeah. Okay, so those are the three topics we're just discussing very preliminarily today. We did want to just give a little bit of background, and we're going to turn it over to our working group members in a moment who are going to help facilitate the discussion around those three topics for the day. I know Catherine, Tony, and Amin have worked hard on this, and we may be kind of toggling between slides a little bit if people want to go back to certain authorities when we're discussing the specific bucket of topic. So relevant today are two main IOLTA statute provisions, section 6213 and section 6215, which I'll show on the screen in a moment, just to show the universe, the sort of ecosystem that's really driving some of the support center work. And then these state bar rules are particularly relevant: operation in California, primary purpose and function, delivery of civil legal services, that many will remember was at issue a little bit ago when we were defining and expanding the definition of civil legal services, and then application for trust fund program grants. And then we do want to highlight as well that there are eligibility guidelines. There's a number of pages that are pertaining to support center work in our eligibility guidelines that staff and others use often, that have further guidance. They're not statutory or state bar rules per se, but those have been used over the years, and those are part of the conversation. And I've just highlighted a couple of the guidelines, but there are many more that pertain to support centers. I just added those for quick reference. And if anyone needs copies of anything or can't find things online, of course, staff are always happy to share with commissioners and stakeholders any of these provisions. And then we won't spend time, we want to get into the discussion, but I won't spend too much time on reading these out loud, but just sharing for the group what constitutes a qualified support center under the IOLTA statute here. You can see that, just my screen for a second. Basically, I'll just read the beginning because it does animate the discussion. A qualified support center means an incorporated nonprofit legal services center that has as its primary purpose and function the provision of legal training, legal technical assistance, or advocacy support for civil legal services without charge, and which actually provides through an office in California a significant level of legal training, legal technical assistance, or advocacy support without charge to qualified legal services projects on a statewide basis in California. I did read the whole thing, but I won't read both statutes or statutory provisions. And then deeming, Erica already went over, which is covered in the second portion here. So that just kind of frames for you the IOLTA statute. And we're not talking about changing the statute. We're talking about updating the rules that, basically elucidate the statute. So these are the relevant rules for support centers that we've been focused on in the working group. I won't read them all. We can harken back to them as we need to in the discussion. But this is more detail on how support centers are governed. And I don't know if there are any questions or things to add on relevant authorities before we dive in to the discussion. Again, I want to leave enough time for each topic. We're thinking around 10 to 15 minutes on each of those three topics that I started outlining in the beginning. So just to flag too, these are the guideline provisions that I alluded to, such as through an office in California, And you can see here some details on how the guidelines add even more detail to the IOTA statute and even more detail to the state bar rules. Okay, so let's dive in and then we can toggle back as we need to those authorities if people have questions. And we are actually going to do this slightly out of order because our amazing working group members' schedules were super busy. So we're going to start today with this topic, which is defining legal training, legal technical assistance, or advocacy support. And I'm going to turn it over. Erica, I don't know if you have any other prefacing comments before we turn it over to our esteemed working group members. Catherine's going to kick us off, but Erica, anything else before we dive in?
No, go ahead. Thanks.
Okay, so Catherine, it would be wonderful if this is a good juncture to kick us off with discussion around this topic. Thank you so much.
So, I mean, I think this is one of the most important topics because it describes or is designed to describe the work that support centers do. And so the three buckets are legal training, legal technical assistance, and Kim has given an example of each of those. And my guess is going to be that those examples are perfectly good examples and not controversial. I think when these topics come up, sometimes there are other examples that are a little bit harder, maybe. And advocacy support, which can be sort of doing more direct work. In this case, she gave an example of an amicus brief that's being written along with or in support of a QLSP. So those are the three buckets, and our task is to identify what we think belongs in that bucket, and it can be rule language. And I'll say two things that we've preliminarily thought about. When the Rules Committee worked on the definition of civil legal services, we came up with a definition, and then we had what we fondly call a chart that gave some examples. This falls within it, this doesn't fall within it, and we thought that kind of descriptive information could be helpful. And I think the plan is for there to be a memo that accompanies the rules, and the memos will be sort of where the historical information lives in a chart, such as was done with the definition of civil legal services, might be helpful here. So that'll give us the opportunity to give some concrete examples of what would be within and what wouldn't be within. So our idea is to, and I guess connected to that is, for some of this, when we talk about what is legal, we think the Trust Fund Commission did a lot of work on what are civil legal services, and it is a definition that is more expansive than what was used in the past. And we think that definition of what is civil legal services, while not exactly the same for the words we're using here, but it could provide some guidance about what is a legal service, and if, for example, might include, advocacy support with analyzing a piece of legislation, but the definition does not, by way of example, include community organizing to pass that piece of legislation, right? So that's kind of the distinction. So when you're thinking of advocacy support, we might think of that being an example and including maybe that in the definition, and then being clear that some things, which is sort of that grassroots piece of getting the community to help pass that might not be included. So we haven't made any final decisions, but just trying to give you a flavor of our thinking about how might we work on these topics. So with that, I'm gonna be quiet and see if people, particularly non-working group members, have ideas about these. And if you want to go backwards to what is like the current guideline or what does the rules say about these, we can certainly do that.
Thank you, Catherine. Yeah, we look forward to any input on those buckets. I'm happy to toggle between the relevant authorities and the discussion slide, but indeed, thank you for framing that. Let me go back to the questions too, so that people can see those readily. So what activities are clearly in line with the above buckets and which are not? And as noted, we provided a couple of examples that we felt that were, pretty typical of those activities or those buckets. but we are curious to get input from non-working group members or others.
I am happy to add a couple of wrinkles, I think, for consideration as we dive into this in the future. I think a lot of support centers will do trainings that's designed for the California QLSP community, but everything now is on Zoom, and so you can't really control who else is in the room. And so what are the guidance around? They spent all their time designing it for QLSPs, but then they have a lot of attorneys from New York, for example. And so especially if it's around federal laws, how it impacts California. And so just, I think it would be helpful to have more guidance around, still should count for primary purpose and like, as long as you designed it for QLSPs, it should count. But is there where's the threshold where you have one QLSP in the room and then, 200 on the Zoom from New York? Another one I've heard too is that a lot of organizations, because QLSPs have asked them to develop some expertise, they may train non-lawyers on legal topics as kind of know your rights, know how to do your own advocacy. And that's often what I see is discussed in the iLaw reports and those conversations is it's training, it's kind of quasi-training technical assistance advocacy to benefit the client community, but it's at the request of QLSPs who ask them to develop expertise, but they're no longer partnering with a QLSP.
So Selena, in that example, are they partnering with the QLSP to do the training, or the training is done by the support center who's training the community? I guess I'm just trying to understand. I don't know whether it matters or not. I'm just trying to understand the example you gave.
I think this is the part that State Bar staff have evolved their interpretation on over the years, is when the training is done by support center staff, may have been based on a QLSP request, but the training isn't with QLSPs and it's for the broader community. So people impacted by, the client community, other advocates, but not QLSPs and perhaps even not attorneys.
Yeah, so that the current framework might be it's training developed and provided to QLSPs, because the purpose of a support center is to support the QLSP. They're not the direct service provider, right? We sort of made that distinction in California, so maybe that's the question you're raising.
And a little bit around the primary purpose piece as well, because the primary purpose bucket is bigger. And so can you count some of this towards your primary purpose, even if you're not using IOLTA dollars for it? Because with support centers, that first is your primary purpose, and it can include people out of state. And then there's like, how do you count your significant level? Which I explained to a lot of new, support center staff that these like two buckets are different, but very related.
They
Right.
are. Almost everything in this topic ends up being related, which is why it has to kind of be taken up as a group, because you pull one thread and you think you decide something, and then you have to think about these other things. Dwan had a comment, and then maybe Erica Conway. I thought I saw her go off mute,
Yeah.
but maybe not.
I have a comment in response to Selena, and then I have a separate comment related to the advocacy support piece. So I think in our office, you're right, like it has kind of evolved over the years, and we don't know if we have evolved it, so it's like has diluted kind of the requirement. I mean, I think the easy application for us, or more easy, more clear, is like if you're developing a legal training and it's for QSP attorneys, QSP advocates, that's the easy. One more removed is it's like a legal aid attorney, or for the legal to help like indigent low income Californians, an attorney, but not at a QSP. I think that seems us more squarely. Where it gets really difficult is when it's like advocates that are non-attorneys that do not live at a QSP. And we have a number of organizations, and I think this is where it's a little bit of a struggle, where that kind of comprehensive training is really useful in their body of work. Like if they are doing child kind of advocacy, and they're actually training like childcare providers themselves, there you could do see kind of that nexus there. But then like where we need, I think, a little bit more definition is like how like how strong does that nexus have to be, right? And we are having a hard time defining that right there for the legal training piece. But I would say for myself, having read a number of applications over the years, the piece for me that's always been really tricky is that advocacy support piece. So the example here is a very clear example of advocacy support that would be qualifying, right? Amicus brief, or if they're actually drafting a bill or, you know, advocating for something with the legislature, that's easy. But we do have, and again, this is not actually a bad thing that programs are doing this, is there's a lot more kind of grassroots kind of organizing that's involved in there. Sometimes the organization will hire like a grassroots advocate. Sometimes they'll fund, you know, outside and work with like CBOs. At what point, because that does support kind of the work, but is that legal support services? I just, we have a very difficult time on that piece.
Well, and doesn't that connect back to this definition of civil legal services?
Yeah.
Right? Like having consistency,
Yeah.
like being able to see a thread that goes across those definitions, I think could be helpful. Like then you're kind of looking at everything through the same lens.
And one related piece to that, Dwan, is that, you know, we think about community justice workers, and I know that's more Jennifer Z's area of expertise, that's her wheelhouse. But, you know, if there are support centers who are incorporating community justice workers in their training, whatever their intended audience, that's just a weird thing to figure out. You know, they may be based at QLSBs, they may be based at food banks in the future. And how do we figure out providing community justice workers and other advocates with the training that they may need to give legal information to people in the community? And all of this to me goes back to sometimes the lack of trust in lawyers and getting the information out to people on the ground who can help people in crisis.
So I get, but there's two pieces to that, Selena, that I heard, like, how do we provide training to the community justice workers who, under at least one proposal, would be supervised by legal aid staff, and how do we make sure they get the skills so they can provide legal advice? So to me, that when you're teaching somebody how to give legal advice and the limitations or what they can do and how far they can go, right? Those kinds of, like, all of that feels like legally related training. That the next step of, I mean, I do think there's a more interesting question about why is a support center training by itself the community? Because that really is defined as what QLSPs do. And I can probably wrap like if it's a partnership where you're maybe when you're doing it because you want that additional expertise when you're training the community, maybe, but you decide just to go off and train the community, that gives me, that no longer feels like a support center function.
And I agree with you on that first point, Catherine. The community justice work. I mean, we actually haven't had like real examples, but you know, when this model started emerging, we did have internal discussions, and we were pretty much all in agreement that with community justice workers, if a support center is going to be training that, because it's supervised by an attorney, that feels like legal, and that's like kind of squarely within that. But I do think your second part to that your comment, Catherine, is the more difficult, interesting.
And it's kind of, the community justice workers are, I mean, at my former organization, we called them advocates, but they represented people in hearings where they could do it, and they needed skills training and they needed legal training, and some support centers were great to provide that. And I think it's in some ways the same for social workers who need training in the law, but we're not going to be offering credits, continuing education credits, so they can maintain their social work license around what are the skills you need to be a good social worker necessarily, right? So I think there's some distinctions there maybe. Do other members of the Rules Committee have thoughts about any of these definitions and things we should be mindful of?
I'll raise my hand. I just wanted to see, so it sounds like there's some degree to which it sounds like, because these are great examples of what's clearly within the bucket. We've been talking about examples where it might not be in the bucket, but it might actually be useful to talk about those examples, you know, of like whether we've found, you know, are there controversial calls that we've made, one way or the other? And it seems as if, one bright line is you have to work with a QLSP, right? Like if you don't have a QLSP attached to whatever your project, whatever you're training them or you're like, for example, is an amicus brief that's not in coordination with the QLSP, but sort of supports the like generally, that feels like not advocacy support, but just advocacy. So I just wanted to see, I'm less well read into this, so it's not as clear to me. What are examples where we definitely are not legal training, we're not legal technical assistance, we're not advocacy support, or like what are the marginal ones? And maybe you don't, I'm sorry to like ask something that you may not be prepared to answer on, but I just wanted to flag, because that's where the boundaries, I don't always see the boundaries.
I think that's exactly what we're struggling with. If you go back to advocacy support, like can you go back to, I think it's under the definition of professional services, Kim? This is the,
Yeah, I don't think Catherine, I don't think professional services is completely defined.
no, maybe it's the direct provision of legal services.
Yeah, and these are the two, like the co-counseling areas.
So this is the co-counsel with an attorney
Right.
employed or recruited by a qualified legal services project.
And Catherine, maybe too, I could quickly just jump in with maybe what I think might be some of those marginal questions.
Yeah, I was just going to point out the B part, which is then there's this current language that says the legal aid program says we can't represent this client, and we'd like you, support center, to directly represent them. And there's no further real contact with the QLSP. And I know at least for one part of a review I was on, I would say there were 15 or 20 cases that the support center was doing under that, none of which had a QLSP connection. And it made me at least think about, like, what does support mean in that context? And this is a rule, it's not in the statute. So it's just an interesting question when you were talking about what are the margins, and that's a margin to me of, yes, it's support because the QLSP thought it was a really important case, but we're losing maybe an opportunity to also support the QLSP and learning some skills to develop their work further. I don't know. Anyway, I just think that to me is an interesting question.
Yes. Yeah. Thank you, Catherine, for highlighting that. Erica, please go ahead.
Well, I was just going to say that was the part that actually I'm glad you flagged that, Catherine, because to me, I look at that provision and I'm like, there's two issues that come up. One is that consistent with the statute? Because the statute doesn't actually, the language of the statute doesn't sort of,
Right.
my read of it is that it's not consistent to like have, even at the request, to like have direct services to a client count as a primary purpose of a support center. So there's that issue of like, if it's not consistent with the statute, we need to like amend that rule anyway. But to your point, Catherine, it seems like, the goal I had always taken of the support centers was your client is the QLSP. And so you are supposed to be helping a QLSP. So if there's no QLSP involvement, that doesn't feel like consistent with the statute. So that to me is where I'm like, well, an amicus brief, again, are we talking about at the request of a QLSP in coordination, like
Well, I think it's the
maybe
same kind of question. Is the brief being done? And this oddly connects to something we'll get to when Amin's here, I think, is about what about national work, right?
Yeah.
Right. But so there are many times where an amicus brief is jointly done by a QLSP and a support center, where the support center has particular expertise and can make better arguments more quickly, etc. But the QLSP is also bringing things to the table and they're working on it jointly. So that one seems easy to me. And then there's the question you asked, which is, if this was a really important issue and the QLSP didn't have anyone that had the time or skills, etc., to file this, would that be okay or not? Which is is the other question you're asking.
Yeah, or I think I'm actually thinking I'm actually envisioning something that is one question, but I have a slightly different one, which is what if the QLSP is the one pursuing the litigation and they want the support center to come in as an amicus alongside them? Is that support work, or is that is that advocacy support, or is that the QLSP acting or the support center acting on its own, even if it is aligned? Like, I guess it's to me a question of like, what does support mean? Is it support for the mission, or is it support for a QLSP to practice? And I'm not sure I have an answer for that. I tend to think my read of the statute, at least, and not being on the working group, so the working group people should correct me if I have a misunderstanding, is that it is more about supporting the legal work of the QLSP versus supporting the ultimate goal of a QLSP. But I don't know if that's too narrow of a read. And I also
think
don't
it's-
know.
Yeah, go ahead, sorry.
And I also don't know if that is not how support centers have been operating, such that it would create kind of a major upheaval, in our funding and in our rules making on this. And maybe there's something in between. But those are the questions that all of this raises for me.
Yeah, I think those are the right questions, and I think there's a variety of those sort of gray areas where different support centers do things differently, and QLSPs would support some of that work, I think. And so trying to come up with a rule that doesn't upend everything, but provides the clarity for staff, I think is our goal.
Yeah. If I could just add quickly, and I appreciate this emphasis on the co-counseling and litigation side, where, support centers are really kind of providing direct services at times, like on individual case or class case as co-counsel with QLSPs. I've done that in several instances in my past with support centers as a QLSP person. And I would just flag to that support idea, when you enter a co-counseling agreement between a QLSP and a support center, you're co-counsel. That's an equitable relationship in the case. Your retainer is signed, collectively with the clients, et cetera. So just an interesting idea, like even from a case strategy perspective, like I would say support centers view themselves as equitable partners, as co-counsel with QLSPs, not supporting the QLSP per se, but that might be something interesting to look at further. And I appreciate the emphasis on this, because we have in the working group been focused really much more on these legal support services, training, technical assistance, and advocacy support apart from or distinct from co-counseling or at the request of QLSPs when support centers litigate. So thank you for flagging this. I think it's really interesting and helpful.
So go ahead, please.
I do think perhaps an example that would get at the distinction that Erica was making that's come up is we have had support centers approach us about, say, an appeal that came up that they were approached about taking, but it didn't come from a QLSP, but they are aware that members of the QLSP community would like them to take that case because it would be beneficial if they were successful. And sort of how to approach that, whether they should take it or because it wasn't, they're not partnering with the QLSP. It didn't come up from the work of the QLSP, and but that everybody, at least who they had spoken with, could agree that it was a desirable thing to pursue. I think those are the thornier questions that
Which
we're
have
not
an
always clear on.
intersection with kind of the national work that
Right.
and does it benefit, right?
Right.
And kind of that discussion. I just wanted to note that Erin Smith had her hand up. So maybe we'll close out this topic just so we stay kind of on time with the other two thorny questions we have. And hear from Erin and then go on to the next topic, because we'll definitely be coming back to you with some more thinking about this. Can we, yep, I think now you're unmuted, Erin, I think.
Great. Thank you. Yeah, I appreciate you giving me a chance to weigh in here. Yeah, and really interesting conversation. Thank you all so much for all the, thought and care that you're putting into this. I just wanted to weigh in on the point that Erica Carroll, well, actually both the Ericas, I think were just making this kind of gray area question of just, whether a support center's advocacy support needs to directly support work that is actively being done by a QLSP, like it's an open case, or it's something that's a QLSP staff is actively working on, such as an example of like co-counseling a case. That's an easy, example as we've noted. Versus if the support can be more like, I think Erica Connolly phrased it as like the mission, or, in Erica Carroll's recent example, like a QLSP supports the goal of a case, and that the outcome of that case will directly impact their clients that they are actively working on, right? But they may not have capacity to co-counsel. So I just wanted to say that and to Erica Connolly's question, like would a narrower reading kind of cause a sea change, or like a drastic change in how support centers are looking and interpreting these rules? I think it would. I think that the general understanding is the kind of support of like the goals or the missions, or something that will directly help the clients of the QLSP, but not tying it to whether that QLSP has capacity in that moment to actively work on a case. And because I think like and I'm sure Selena is, has her finger on the pulse of this, but there's just so many capacity constraints in these organizations. Everyone is working so hard, and there's never enough hours in the day, and way more clients than anyone can ever help. That, if the goal is to, really expand civil legal services to as many Californians as possible, I think a narrow kind of construction there, like requiring a QLSP to be, co-working on everything with a support center, is really going to constrain the overall field's ability to serve more Californians. And so to take a broader look there really, I think, serves the overall goal and mission, of providing civil legal services. I had a second point that I just escaped me.
Well, thanks for that. And Dwan has her hand up, so maybe we'll go to Dwan, and then we can loop back and see if you have something quick to say, and then move on to our next topic,
Yeah.
I think.
And I'm quick. I was just going to agree with Erin, because I think, especially with litigation, there's so many legal aid programs that we don't fund and that are doing really great work right now. The ACLU is an example. And a narrow reading of that, not giving our support centers the ability to sign on or support that type of work, feels maybe a little bit too limiting to me.
Yeah, I think there's like, I guess, to Erica Conway's point about like what's consistent with the statute, of course, right? Like, are there some parameters around that? Because I don't think we would want to say a support center could spend 100% of its time doing the broader mission type work to the exclusion of doing other things. I'm not suggesting that's happening, but like, so are there some parameters about that? Is it a percent of time, or are there some connections back to the QLSP community that engage them in what's happening and sort of the policy decisions, not that might come up in the case, and get their input? Like, I think there's a way to bring it back to supporting QLSPs in an indirect way, as opposed to not connected at all, which is a piece of what I think can happen. So I think some really good food for thought in all of that, and appreciate Erin jumping on to share her perspective, and yours, Dwan, too. So why don't we go to the requirement around an office? It doesn't really say office space, it just says an office, which I think gives some flexibility, but Tony has been thinking about this and is going to lead us through that discussion. So thanks, Tony.
Yeah, thank you. Can we go to slide 12 really quick, just so
And I'm going to just get some water, so I'm not going away.
thank you.
I'm really thirsty, but I think we have to say why we're leaving.
Thank you. No worries. Sorry, Tony, my slides are a little bit numbered differently. Can you give me
The relevant authorities guideline 2.25.
Okay, great.
Yes.
Thank you.
Thank you. So I just wanted to ground this group since they haven't participated in this, but really this is specific to Rule 3.67B, the operations in California by qualified entities. And what's in focus here is what Catherine just mentioned, is through an office in California. And some commentary was that you must actually have a regularly functioning office physically located in California and provide these services through that office. And it must have been in existence and operating prior to your application with LSTF program grant. In the team, we had a lot of discussions about this, and a lot of the discussions was around striking a balance between ensuring that organizations maintain meaningful connection to California, allowing them to, and then also allowing them to operate flexibly, considering the new working dynamics. As you know, with COVID, a lot of these organizations have gone virtual. And we have had a lot of conversations around, well, what does through an office in California, what should that mean now, considering the changes in the shifting changes in the working environment, where we're shifting away from in-person, or we're shifting away from in-person brick and mortar offices to more virtual offices. How do we kind of change with the times, but then also at the same time recognize that there are vulnerable communities that need to be served in person, while there are still others that, really benefit and could potentially serve more clients through remote engagement. So those are some of the things that we talked about in our discussions. Can you go to the discussion slide now, please, Kim? And so here are just a few questions that Kim and the team, kind of Kim and Erica specifically, helped put together to kind of start the conversation with this team, is, regarding actually provides through an office in California. What considerations should we consider as a part of this, in addition to the ones that I kind of noted earlier, and how do we balance all of this? And, there has been some conversations around, like, what is having an office? Is that a physical address and a PO box, maybe serve as a process? So I'll stop there and I'll open it up for comments and discussions.
Thanks, Tony. Appreciate any input from the committee and commissioners and stakeholders. Erica has her hand raised.
Sorry, I asked lots of questions. I was on the working group, so sorry in advance. I understand that there's like the office part, and I work remotely. I love working remotely. I think promoting remote work is like really critical, for all kinds of reasons, including recruitment and retention of employees, right? So I want to be as kind of expansive as we can be. One question I did have is there a requirement that the support center be incorporated in California? So I thought in the QLSP context, you had to be incorporated in California, but that was
incorporated. The statute said an incorporated nonprofit. I don't know. Somebody else would need to speak to whether it's.
That did come up during our conversation, and it was no.
Right.
They did not have to be incorporated.
So the support center does not need to be incorporated in California as long as it has an office here. But QLSPs, though, do need to be incorporated in California, correct?
Exactly.
Yes. Yeah.
Okay, that's fine. I just wanted to make sure I understood which was which.
Right.
Do we have support centers that are incorporated outside of California? Okay, so we do.
Mhm.
Interesting.
One thing to quickly add to everyone's kind of background is that this is the statute, which actually provides through an office in California. So that's pretty much actually provides through an office in California is all it says in the statute. And the rules are being amended right now. And then the eligibility guideline is helpful, but folks should know, and please, Erica, Dawn, please chime in as needed, but the guidelines are not statute, are not rules. So while this has been suggested guidance, this is not binding. So this idea of having a physical office located in California is not binding. So that's why we're looking more at how the rules could be amended and updated, to Tony's great points.
Right, but the statute does say office, so we essentially have to define what an office is.
Yes.
Yeah.
One other thing that I think is applicable to all three of these areas we're talking about today is staff application of these guidelines. So, we've talked internally about what office means and what it could mean: physical address, office space, PO box, desk or not, how many staff being in California, et cetera. But I just want to flag, as a staff member, when we look at IOLTA EAF applications and when we're doing, monitoring visits and, whatnot, and looking at the support center work, we have to be able also to verify adherence to
Right.
these guidelines. So that's just something to flag with all these buckets. It's like, how do we make sure to double check these things in a way that works for grantees and for staff?
Can I ask, have you guys talked about having a registered agent for service of process? So a lot of out of state, sorry, Tony's like laughing or smiling. Is that, what's the thought on that one? Because that's one way I know out of states at least have some connection.
Mm-hmm.
Is
Erica,
that
Carol,
possible?
do you want to chime in on that?
Did Tony want to say?
Yeah, I was
don't
gonna
know.
let Tony go ahead.
Yeah, please.
and then-
Oh, yeah, no, I think we did talk about that. Kim had brought that up. She had spoken to the state bar attorney, and I think that there was a thought that that could potentially be one of those things. But I think we're having the conversation today, not because we want to really just keep it broad, and we want to make sure that it strikes the right balance, right, between that broadness of being able to have people work from other places, but then also benefit. We know that there are lots of benefits for having the support centers actually be in California. So I feel like, we've had this conversation, and it's kind of like, it's a case by case basis where, if you are serving clients that are, or organizations that are more in-person based, then the value is in that in-person conversation versus something more virtual. So we have had conversations around that. Catherine, did you want to add anything?
No, I'll make a comment later, but I think Selena has her hand up too.
We gather support centers pretty regularly in ways. We just gathered them last week. And how are you supporting the QLSP community right now? What are you doing? And we gathered support centers, I think, last year, specifically on the topic of physical office. Many organizations, their leases were up. They were mostly remote. They were thinking about getting rid of the physical office. I'm sure they all asked you about this. But when we gathered people, that was one that once we were in the room talking about it, they were less worried about this. When we use these hypotheticals of national organizations with no California nexus or very little California nexus, or say an organization incorporated, mostly working in Chicago, but they wanted to get their foot in the door with California. The existing support centers did not mind having a physical office because it seemed to be the best way to say that this is the California Support Center community, and these are our people. So I think that organizations want to have some flexibility around, like, how big does our office need to be? How much do we need to be in the office? Can we share office space with another support center? Like, those are ideas they were really interested in, especially on like collaboration, like 3 support centers could share one office. But I did not hear very much concern after the conversation with people saying that urging the state bar to remove that requirement. So I thought that was helpful because I had previously been hearing, like, let's save money, let's get rid of our office.
It looks like Dawn has her hand raised.
I was gonna say, I heard a little bit of the contrary. There are actually a couple support centers that called us that we actually gave the advice that we're gonna try to do a rule change. And we thought it would be a little bit quicker on this one. And I know have given up their office space. And I know how pervasive it is, but I do know that there's like a handful that was a consideration that now do not have. So I didn't hear it as like the size, but it was to me more of an office at all. So.
Thank you. And Erica Connolly, hand raise. And then Catherine.
Sorry, so just a quick question, kind of keying off of what Sino was saying, do the current support centers have concerns that if we broaden this too much, there is going to be more competition for funds? Is that, okay? Yeah.
So
You know,
go ahead. Sorry, Erica.
no, all I was gonna, just my comment on that is like, I want to be supportive of like a California-based community. We obviously want to balance that without being too protectionist on it, but okay, that's helpful to know that that's like a concern if we go too broad. Thank you.
And just a quick clarifying note is if they're a national nonprofit that had really significant California nexus, but they didn't have an office, these were all like, it feels a little different if they were already doing a lot of virtual services in California, or they had attorneys who traveled to California for in-person trainings. It really was the hypothetical of a national nonprofit with dwindling resources thinking, oh, California IOLTA, that's a way we can get some money, is applying for California IOLTA.
So I guess one of the factors I've thought about is separate from the physical space. I feel like having staff in California is a commitment to doing work for California. And I've had experiences long ago now, but the protection and advocacy system nationally initially had its support centers all on the East Coast. And it's really a disadvantage to people in California and Hawaii and other places because their working hours don't really align. And unless they're very intentional about how they create that space so that you can access the same number of hours of service a day, it's just a barrier for people being able to get in touch with them and get the answers they need timely. Like you want an answer that day, but now it's 7 o'clock, right? There is something I think about the idea of an office isn't just a physical place. It is people and a connection to the work in the California community, which I think is important.
Yeah, if I could too, thank you, Catherine. I just want to also add, I've done cases as a former grantee across 3 time zones and completely get that point. And also, what I've heard in our monitoring visits with grantees is some folks saying, my senior veteran clients will only meet me in person in a conference room. They just can't do a Zoom call. They can't do a phone call. They need to see me in person and see those documents in real life. And the power of that from even a support center or a QLSP is real. On the other hand, I've heard very similarly situated grantees saying, we will not see our clients unless we do phone calls or Zoom calls. They don't want to come in and they're even fearful of coming in for various reasons. So having a remote connection with clients or client communities or attorneys can be really powerful. So what I've been struck by in our canvassing for information is just the spectrum is really broad and wide. And I think we're all in agreement that we want to be as inclusive and as real about legal services as possible. Erica Connolly?
Thanks. Okay, so I have another question along this lines. I think Catherine's point about having this like greater, like an actual presence and a connection with the state is really important. The question I have is like back to like Selena's issue, right? Dwindling sources, someone outside, they like, they rent a really tiny office or they co-rent with someone. Are we under the statute? Can we say that's not sufficient? Or is the physical office something that we have to allow for, but then we can broaden the definition? Or can we say a physical office is insufficient?
I think physical's not in the statute, I thought. It's just an office
No.
is in the statute.
That's
The physical is in a guideline, I think.
Yeah.
Tony is the
Sure,
expert
I
on this.
That's
understand.
correct.
But I guess what I'm asking is, and this may be the answer to the question is it the like view that like a physical office would not necessarily satisfy the statutory language saying an office in California?
I think we can make an argument that just having a small office that nobody ever goes to is not an office. Like, I just think that's the opportunity we have to define what we mean by office.
Okay.
Selena, thank you. And I'll just quickly add that, things like significant level and statewide and deeming are another means for figuring out whether a support center is in fact in concert with the QLSP community, the legal aid community in California. So this is not, the office wouldn't be the only kind of hook to keep a support center connected to the state. Selena?
I love how we're defining office based on a statute written in 1981. I feel like, to Catherine's point, an empty office that no one goes into and nobody checks mail and it's all scanned and forwarded doesn't feel like an office. But similar, or I guess the flip side is that 20 attorneys and 20 attorneys and their other directors working from home in California and traveling and training QLSPs in person, like that feels like a physical presence in California, because all of their people are here. So there has to be some way that we define office. It's more about the people and less about I don't know how to define it. That's why I have a working group.
Thank you. Dewan raised hand.
Well, I was gonna say, I think the office we've been using as a proxy for whatever this other thing is, right? Presence, accessibility, ability to access services. But the other thing to consider is, obviously it's easier to do a rule change that fits within the statutory framework. But I think maybe at the end of the day, if the office like kind of framework really just doesn't fit, there is probably a potential that maybe we can have a conversation with the legislature to just remove that office, give the commission a little bit more flexibility and rework our framework. I'm not saying we do that, but I'm just saying that's not completely out of your realm. I don't know if that would happen, but it's just something to think about if we're trying to somehow fit a peg and it's just not working. I don't know if we're there yet, but I just wanted to put that out as an option.
Mm-hmm.
I know that during our conversation, I think Amin brought this up on the conversation about like the intent behind this rule.
Mm-hmm.
Were you able to find some information regarding the intent behind the rule?
I'm not aware of, and Erica Carroll, please chime in, but legislative history that speaks to this exact.
I have a box that you guys can go through that Brady has done a sweep for me. I don't think you're going to be able to find anything. He's done a sweep for me a couple of years ago to find anything related to Covenant.
Mm-hmm.
You're welcome to go through it again, but it's probably very little.
I'm going to go back to what Selena said, which is the legislative history it was a 1980 statute. And I think we all know what an office meant in 1980.
Yeah, but I guess my thing is like it's more of the intent of having the office, right? What is the intent of having the office
presence
space?
it was designed to say you are present in California, and I think we have flexibility to say presence in California now means something beyond just an office, right?
I agree.
Yeah.
Okay. Mindful of time, and I know Amin was hoping to join for this section,
But we can still do the next piece, I think. I don't.
Okay. Yeah. Should we
just might have been delayed and join or something.
Yeah, we're ready to help on that section. Let me just get my screen back up on that slide. But yeah, and I think we all want to make sure that folks feel that they can add input along the way of this journey. So to the extent that people think of input beyond the meeting, we're looking forward to continuing collecting it. And then mid-2025, we would be circulating potential rule amendments amongst the legal aid community. So that'll be another juncture. So let me go to the third of this phase one set of topics. Catherine, do you want to tee us up on this one? Thank you.
Yeah. So this is really about out-of-state work. And I think we're just noodling through because some support centers conduct work in other states that may or may not benefit Californians. So an example that has an impact on California is you're the National Health Law Center and you do a lot of Medicaid litigation, and you have a case that's in the Ninth Circuit, but it was brought with legal aid from Arizona, but that case is going to impact what happens in California because it's going to become a Ninth Circuit decision. So that's an example of sort of a case with a more direct connection, I think. But there's other cases that people do that are out of state, and I think the state bar staff can certainly speak. I just think these questions come up sometimes. Is a case that was brought in state court in Maryland, something that's going to have an impact on California, or a lot of other examples. So we're interested in just your wisdom about, are there things we should consider about out of state work and how that counts for a variety of different purposes?
Thank you, Catherine. And two, I would just add that there, unlike the other two areas we were discussing where we're really editing existing rules, this is an area where we'd be in some ways adding a new section to the rules. And there's not a lot existing right now in the guidelines on this. So this would be more whole cloth. And then correct me if I'm wrong, Erica, but as I understand it, this is not about primary purpose. This is more about qualifying expenditures. So it is okay for support centers to do work outside of California. We know that already. This is a sort of that secondary aspect of what money would be eligible for a grant that they, in terms of activities they do outside of California that in fact do benefit Californians.
Yeah, yes.
Erica? Yeah, please go ahead.
Do we do this? I thought we did this with QLSPs. What do we do with QLSPs when it's about their out of state? I know we've had this debate
We
before.
have these
There's like a
mind
nexus
melds, Erica,
question.
right? I think those topics come up, and how it's considered for a QLSP is could be a proxy. So the QLSPs have to go through an analysis of like, is it an exclusion for things that are out of state? And that's kind of where it comes up, right? Like, was there a nexus to California? But I think Erica Carroll has something to say about this, as I recall from before.
Yes, so the statute says that QLSPs are supposed to operate exclusively in California, but there is language in the eligibility guidelines that I'm trying to find that speaks to if they're doing work outside of California that's beneficial. That I just need a moment to look for, but
That'd be great. While Erica's looking, do other people have anything they want to add to this?
I guess the only thing I would maybe just contribute, and this is maybe where I'm pulling from the QLSP part of it, is it seems like it would be beneficial to have support centers at least explain, if it's not obvious from the nature of the work, how it connects to work in California. So, I think it's one thing if your amicus brief cites like this case will impact California. Okay, fine, that's a very easy thing to point to. But if it's a little bit less direct, it might be helpful. Like you said, like Ninth Circuit stuff, there's lots of states that you can be operating in that will, more clearly impact California. But yeah, that's my 2 cents is I don't think it's unfair to have some opportunity for them to explain the connection, but it seems to me like beneficial to be willing to allow qualified expenditures for them to do work, especially as a support center where they're sort of doing, supporting QLSPs that might need to do that work outside or whatever. I do wonder, like, what are examples where support centers are doing that kind of work outside of state? I know you mentioned like this Maryland. Is it like an amicus brief or?
I just made up Maryland. I think. So.
Oh, okay. Sorry.
You could do something in a state court that I think has less impact on what's going to happen in California. But the other thing I will say is there are lots of federal statutes that
Yeah.
apply across the whole gamut, like it's whether it's
Totally.
the special ed statute or Medicaid or Fair Housing Act or all of that,
Yep.
that can benefit what happens in California. So I agree there has to be a way to allow
Yeah.
some of that. But in some ways, it also goes, I think, to the good questions Aaron Smith was also asking about what does support mean, right?
Yes.
If you were a support center and your primary focus was work on the East Coast, let's just say, and your litigation was all there, I'm not sure that that also means you're supporting California legal aid programs as
Exactly.
directly as we might want, right? And so again, it's
Yeah.
kind of looking at like, is it a percentage or is it how there's a connection back to what
Yeah.
you're in communication with QLSPs in California about that. I don't know, there should be a bit more than just go off in whatever cases you have to do, which I think is what you're getting to. Tell us how this benefits California. What was your connection to the QLSP community or whatever that we would want them to explain?
Yeah, I mean, I think my sense is like, look, there's a lot of strategic forum choosing these days, and so we don't always get to be, especially when it comes to federal regulations and statutes. So I definitely don't want to be precluding, and I maybe am too litigation focused, and there's other advocacy stuff too, but I don't want to be limiting people doing work in whatever state the particular battle is being waged in. But yes, I think an explanation of like how you're benefiting California, and to your point, like how are you benefiting California QLSPs as a support center is, I think, maybe the explanation that needs to happen, right? Because, and I don't remember, but for support centers, do they count as qualified expenditures, not just their support work, but also like any work for
They
indigent
don't have
individuals?
qualified expenditures in the same way because
Oh, right, they don't do the allocation. Yeah,
They
yeah,
don't
yeah.
do the allocation, they just
they
get
get
their
the pro-
money.
yeah.
But this goes to, I think this is what either Dwan or Kim were saying, I think, which is you're separate from your primary purpose, which can be broader. You could be helping legal aids in other jurisdictions and still meet the primary purpose. The theory is you're supposed to spend the money California gives you for the benefit of California, right? And so I think that's in part what we're talking about here is we now gave you money and you have to show that you expended the money in a way. And one factor is like, is it benefiting California?
Right. Yeah. The nexus, I think, has come up a few
Yeah.
times, and that I think was a good way of staging it. Well, gosh, I think we're almost at the full amount of time that we allotted to these topics. And I know maybe Erica, I don't know if you want to add more. Erica, Carol.
Well, I think that we have the good news is you'll get to leave before 4 o'clock. So even if we take a little extra time.
Oh, yeah,
Other things
absolutely.
to say, we can.
Yeah, we have some time. Yeah, absolutely.
Just to circle back to the
Guideline.
QLSP analogy. So like I said, the statute says that they need to operate exclusively in California. The eligibility guidelines say that if you have activities outside of the state, that's okay, but it essentially just clarifies that you cannot use state bar funds outside of California in the QLSP context. And we would also have them deduct that on their application as non-qualifying work.
So it's
But
that's
because
a little bit different then.
Yeah.
The stricter standard about what you can do.
Correct.
It's really a primary purpose. Are you spending most of your time outside the state, which would mean you're deducting.
Exactly.
Right.
And so I think
Thank you.
Where it's come up though, Catherine, was with ILA, there was question about whether, even though it's out of state, not that they're using state bar money, but they're saying this is benefiting our clients in California. And that's where those discussions have come up for QLSPs, where I think it's been a little bit more treated as a discretionary decision about whether to count it as a qualified expenditure or not. For primary purpose, but there's no dispute that they would not be using state bar funds.
Yeah.
So.
Yeah, thank you for that.
Yeah.
I'm just noting, Erin Smith had her hand up. So Erin, why don't we give you a little quick time to comment on this topic?
Thanks, and yeah, I didn't realize you were trying to stop by 2. So I'll try
Oh,
to be.
I think we're
Oh.
flexible, but I just wanted to
okay.
make sure everyone had the time they wanted to share. Yeah.
Oh, thank you. Yeah, I mean, I think this conversation is very similar, if not the same, as the one where I chimed in earlier. It's kind of, well, but and to the point of, what metric, should we use to determine if a support center's work is sort of benefiting California to the degree that we expect? My sense is that, when you're looking at whether it counts as the significant level of service to support centers and what it means to be an advocacy support service to a support center, that piece that we were talking about earlier of, has it been requested by a support center, or are you co-counseling with a support center, or what degree of kind of coordination is required between the support center and the QSP could maybe answer this question, right? So like if you just look like, did a QLSP ask a support center to participate in this case taking place at the US Supreme Court? If so, then could that be enough signal that we need to say, well, clearly it's important to Californians because the California QLSP asked them to do that. And then, I'm just kind of wondering, like, if in addition to that, at the request of language, which I think is in a state bar rule, but not the statute, if it could also kind of capture, like on behalf of or in coordination with or something like that, to capture a situation where a support center might say, oh my gosh, there's this really important Ninth Circuit case, or Supreme Court, it's gonna impact California. We can participate, and then if they go get like feedback from QLSPs on like what the position should be or something like that, but a QLSP doesn't have a staff person with time to actually draft anything or engage further, but if it's kind of in that degree of coordination, like, couldn't that tell us? So that, like, that nexus to the QLSP, I guess, is what I'm wondering, if that can tell us if it benefits California enough.
Yeah, I think that's right. And like, as I said, with the other, I think they're very similar discussions, as you pointed out. I just think having some connection back to QLSP so they actually know what's happening. They have the opportunity to react to the strategy that's being done. I mean, I think there's sort of touch points that we might be able to identify. So
One thing to add too that's been on my mind throughout this process is we, as a former QLSP and in touch with support centers, there are some QLSPs that know a lot about support centers. There are some QLSP attorneys and leadership that don't know a lot about the support centers, don't always, despite great efforts by LAC and other stakeholders. I just want to flag that there's not quite a perfect universe where every QLSP knows exactly which support center they can turn to or which support center they should tap if they have an idea for an effort that the support center could then support. It's not quite as linear sometimes, I think, as we might hope. So I'm excited to try and, reflect that reality as much as we can in the rules and in our state bar support work so that the ecosystem of support centers and QLSPs even know each other that much better if possible. Tony.
Sort of on the same line as what you're talking about, Kim, I slightly recall a conversation in our working group meeting where you had said one of the examples you used was if they were lobbying for legislation that could impact California. I don't see that in instances like that, they would be working directly with a QLSP to do that, but that lobbying could potentially be beneficial to Californians.
Yeah. Thank you, Tony. Erica?
Well, I think one of the things, to somewhat in support of what Erin was suggesting is like, and that may address, Kim, your point, is like, if we kind of put the standard as, and maybe it's more of a presumption than a requirement, that like you have you can show concrete interaction with the QLSP, maybe that addresses the issue of like, support, teaching support centers about, or teaching QLSPs about support centers, right? Like if we incentivize support centers to reach out to QLSPs and educate them about what work they do, because they need the QLSPs to pair up with if they want to do this in order to get qualified, whatever, to get over whatever hump we need them to get over, for their expenses. I'm just wondering if we can kind of hit two birds with one stone, right? It's a way to show, and it's a way to incentivize more contacts between the two.
Mhm.
Yeah.
I do like presumptions rather than requirements, just because I think there's always an exception. But I defer to the working group on like how to actually structure that.
Thank you.
Thanks for that wording suggestion too. I think I think these are hard issues which
Yeah.
I don't think there are lots of just clear, if you do this, you're absolutely, it's just hard to
Yeah.
identify what those are. And I think this idea of describe this and here's the things we're interested in knowing about, which puts staff in it's a harder position, I think, but I'm not sure there's this bright line for office or other things, but I think we can do a good job describing what we want to see the support center demonstrate, right? So
Yeah. I mean, I think what we've done in other rules is where we've struggled with this is we've sort of created like a list of factors, right?
Mhm.
Here, in making its decision, these are the list of factors that we will
Yeah.
consider, and that
Yeah.
might be one attempt here, right? So, and it gives us a little bit of discretion.
Yeah.
So.
Perfect. So really, I thought this was a great discussion. Grateful for the people that put the slides together and did the framing, and for all of the input. Those of you that weighed in, if you have other comments, this is not your only opportunity. I think as Kim and others said, we'd love to hear from you. I think we have another meeting coming up in May, and we'll report back at our next meeting with some other topics to talk about as well. So I think we're Erica, Carol, we're done with the agenda, right?
Yes.
Look at that. 2 hours. You get 2 hours on a Friday back. Who doesn't love that?
Thank
Very
you,
happy.
Catherine.
Every time I see 12 to 4, I'm a little daunted. So thank you for not making it all the way to
and me
4.
both. I'm like, whew, anyway, good. But we got a lot out of this conversation. So really, really appreciate all of you. I don't think do we need a motion to adjourn? I'm always confused about that. No.
No.
Not? So go forth and enjoy your weekend.
Thank you guys. Thank you for
you.
work.
Everyone.
Bye.
Great weekend.